Yes, Mr. Gammy.
Good afternoon, my lord, my ladies. I shall deal for the LLP with our ground one appeal, where we say that we're entitled to the entirety of our claim for BPRA. And I will then deal with the capital amount and the residual sum before I hand over to my learned friend, Bremner, who deal with our ground two and the various specific items that the revenue have raised in their grounds of appeal. I think I will be very brief, which may be of more concern to Mr. Bremner if he has to get going this afternoon. Leaving aside the amount of the expenditure claimed in this case, this was a tax incentivised development project that was sold into the market for £15.5 million. Now I say that because the Revenue accept that this project qualifies for BPRA to a certain extent. There is an ongoing dispute as to precisely how much of the expenditure qualifies, but I don't think they can really complain if this was sold into the market as a tax incentivised project development. It was based, the price was based on expert valuation and methodology, which was explained and accepted, we say, by the first tier tribunal. There was extensive explanation of how the price was calculated and how the Edward Simmons valuation was arrived at and why that was a correct valuation and that was accepted by the first tier tribunal. First tier tribunal did not disagree with any of the material that the LLP had put forward by way of expert evidence or even factual evidence as to what was done, as to how that price was arrived at. And it appears in the information memorandum, which might be just a good place to start fairly briefly. It's in the supplementary bundle at tab 19, page 359. My own friend Mr. Macklin took you to that this morning. And if I can just get my machine to get in front of me. Yes, so that's the front page. And on page 389 of the bundle, we just see the definition of the total purchase price of that the bottom of the page, I think. Total purchase price, total cost of acquiring and refurbishing the property being £15.5 million. And within the information memorandum, because it will be relevant for what we see or have to consider later, I just draw your attention to page 377 of the bundle, which deals with the ownership of the hotel and the developer's capital account, where the capital account is explained. And then on page 382, we have an explanation of the loan facilities, and you see that the balance, the gearing with which this property is being financed and developed produces 8.3 million by way of loans to the fund, which is 53.5%, and a subscription, which is what the purpose of the information memorandum is to attract from equity investors, 7.2 million, which is 46.5%. And again, the evidence was that that was within the normal range of debt equity for a project development of this nature. And what was the nature of this investment opportunity that was being offered to the market through the information memorandum? It was a project that had been put together by CANOC or OVL, which had identified the opportunity, had done all the necessary work to ensure that this was a development that could be successfully taken through both to completion in terms of the work needed on the building, but also was something that could be funded both by going to a bank to borrow, but also to go into the market to raise the necessary equity that was needed for it at the price that we have seen. And the equity raising, as we know, the first tier tribunal, I think, says explicitly that this was the sort of final link in the chain. So you have to put you have to put the whole proposal together, the project together, in a way that can be sold to people who are prepared to put their money in as equity investment. So that was the final link in the chain, if you like, to create the project that was going to be taken forward, that was going to be funded by raising finance from the bank, from a combination of the bank and what the developer itself would be prepared to loan into the project, and get equity investors to subscribe for it. So when Mr. Tracy talks about it being from cradle to grave, why not? Why not? That's exactly what he, or Cannock or OBL, as a developer, is in business to do, to identify projects that can be undertaken successfully, and in this particular case, that can fall within the scope of a specific incentive devised by government to enable buildings in these particular areas to be developed and brought back into use, productive use, for a future period of time. So it was doing exactly what the incentive was designed to achieve, and the revenue don't say otherwise, in the sense that they accept that this was a project that qualifies for BPRA. They just take issue about the amount of the claim that is made as expenditure incurred on the relevant project. And we say, as you will have seen from our skeleton argument, we say that effectively the LLP raised 15.5 million, and that was expended on two items. It was expended in buying the freehold of the property, and it was expended on paying Cannock for its development obligation, which we can see again, just to go right back to the beginning. I think it's on page 10 of the supplementary bundle, the development agreement, and we can see, just by way of the introduction, that the syndicate has agreed to appoint, this is the introduction on page 10, the syndicate has agreed to appoint the developer to procure the carrying out of the works. In consideration of the works, the syndicate will provide finance for the works to the developer in accordance with the terms of this agreement, and then the operating agreement has agreed to join in this agreement to take the lease. And if we go on to page 18, I think it is, of the bundle, the development agreement, we see, it's not 18, it's page 14. We see the definition of the works. At the bottom of the page means the construction of the development as shown on the approved plans and all other ancillary building, engineering, road, drainage, service and landscaping works, if any, and the provision and installation of the fixtures, fittings and equipment to be carried out by the developer, either within the site or on areas adjacent to the site under the provisions of the Planning Commission and any third-party agreements. So that's basically what is agreed to be done and what the sum is paid for, and we then just need to turn to the legislation to see why we qualify for the allowances, and that's in the authorities bundle, and we know on page 7 of the bundle we see the introduction to business premises renovation allowances. They're available under this part if a person incurs qualifying expenditure in respect of a qualifying building. We know that the LLP has both incurred expenditure and that it is in respect of a qualifying building. And as we're told by section 360A, allowances under this part are made to the person who incurred the expenditure and has the relevant interest in the qualifying building. And then on the next section, 360B, as we've seen, qualifying expenditure means statutory expenditure incurred before the expiry of the date on or in connection with the conversion of a qualifying building, etc. Note, it's not just the conversion of a qualifying building or the renovation of a qualifying building, it's a qualifying building into qualifying business premises. And we see what is meant by qualifying business premises and section 360D. So any premises in respect of which the following requirements are met. The premises must be a qualifying building, it is. The premises must be used or available and suitable for letting for use for the purposes of a trade, profession or vocation, or as offices. It mustn't be used as a dwelling. And then there's a provision we see in subsection 3 to deal with temporarily unsuitable for use, which replicates similar provisions that can be found elsewhere in other buildings allowances provisions. And we can see that the payment that was made to OVL was for precisely that purpose, to carry out the development. And we know that the building eventually opened as a Ramada Encore hotel, subsequently changed to Holiday Inn, and it remains in operation as such by those concerned. And why it needs to, I'm not sure that you've been taken to the specific provision, but if we go on, we can look at, for example, section 360H on page 17, which just tells you that no initial allowance is to be made under section 360 if at the relevant time the qualifying building does not constitute business premises, and relevant time is dealt with by 4. And then on 360M on page 18, we can see when balancing adjustments are made. So it's made if a qualifying expenditure has been incurred in respect of a qualifying building and a balancing event occurs. And a balancing adjustment is either a charge or an allowance. It's made to the person who's incurred the expenditure, but no balancing adjustment is made if the balancing event occurs more than 7 years after the time when the premises were first used or suitable for letting for either of the purposes mentioned in section 360D1B, that's either as an office or for a trade. So this is an incentive which just doesn't allow somebody to invest in a building, take the benefit of sideways loss relief to claim all the allowances, and then exit or find some way of exiting without triggering any adjustment to their position. They have to remain invested for 7 years, and that, of course, is an assessment that's made by the equity investors when they're invited to put up the equity for this project in the information memorandum, and details of that were given in evidence by Mr. Rawlinson. His evidence, I won't take you to it, but his witness statement is in the supplementary bundle at tab 41, page 632, and he explains the analysis he went through as someone who was eminently qualified to look at these sorts of investments and assess them as an appropriate investment, providing an appropriate return, something in which he had to remain invested for over over 7 years, as I think we saw from the information memorandum this morning, 8.5 years at least, he assessed that as an appropriate thing to put his money into and to remain invested in for the required amount of time. So that's the context within which the money was raised, spent by the LLP. It bought itself the freehold and it bought itself the property to be converted into a hotel, which once it had been converted was let and has been operated as a hotel ever since. And we say that that is the beginning and the end of the story. That's what we did with it. That's what we incurred the expenditure on. That's what we got for our money, the freehold, for which we did not claim a BPRA, because if we go back to the relevant section defining qualifying expenditure, 360B on page 8 of the authorities bundle, we see that in subsection 3, expenditure is not qualifying expenditure if it is incurred on or in connection with the acquisition of land or rights in or over land. And of course, if OVL or Cannock had owned the freehold, and what we paid OVL or Cannock, perhaps I'll just call it Cannock, if we paid Cannock 15.5 million, we would obviously have had to have apportioned the 15.5 million between the freehold that we bought from it and the development obligation that it gave us under the development agreement. But the freehold happened to be owned by a third party, an unrelated company called Chancery, and so there wasn't any need for an apportionment in any formal sense, because we paid Chancery the price that it demanded. As our skeleton indicates, we haven't claimed any relief, any BPRA for the stamp duty land tax involved in that purchase, and as a practical matter, following discussions with the revenue, we didn't actually claim for the legal costs involved. That the reasons for that are all dealt with by the first tier tribunal in its decision. But broadly speaking, the balance which is claimed, we say, is allowable. And I say it's allowable really on the authority of just 3 decisions, which will be very familiar to you, which I'll mention, but I won't take you through it in detail. Of course, the first, we say, is BMBF. What BMBF bought from the BGE, the Irish Gas Board, was the section of the pipeline, gas pipeline that ran between Ireland and the United Kingdom. I think I'm correct in saying that actually there was no actual valuation of what they bought. They just paid whatever it was, 92 million or so for the gas pipeline. Nobody actually valued whether or not that was a precise, an appropriate amount to pay for that section of the gas pipeline. My recollection, I was junior counsel in the High Court in BMBF, my recollection is that it was all to do with replacing a grant that had originally come from the European Union. I think it was effectively a refinancing in some way, but I don't think that matters. The point was that it was the price that was agreed to be paid for the pipeline. BMBF acquired the pipeline. The fact that in doing so, as the House of Lords tells us, was effectively to transfer the benefit of the allowances to somebody such as BMBF who could actually utilise them, and the fact that the money that BGE received for the sale of the pipeline was then deposited with an Isle of Man company, and through various complex arrangements dealt with in the certainly in the High Court Commissioners and the High Court, but also summarised very briefly in the House of Lords. The fact that that money started with Barclays, was lent to BMBF, was paid from BMBF to BGE, and was then deposited with a company called Deepstream, and through a series of arrangements effectively was utilised to repay the loan from Barclays, did not deny BMBF the benefit of the allowances, because broadly speaking it had paid 92 million. What it got for its money was the section of the gas pipeline, and that was the end of the story. What BGE did with the money after it had acquired it was neither here nor there. We say exactly the same applies in this particular case, because whatever the fact that this was a tax incentivized investment, exactly the same principle applies in deciding what the LLP got for its money. It got Cannock's development obligation to convert Blush House into a functioning hotel, which it duly did, and which has then remained operational as required by the legislation ever since. And the other authority, of course, I don't think I need take you into BMBF. You have the benefit in the authorities bundle of the decision of Mr. Justice Park in the High Court, the decision of Lord Justices Peter Gibson, Ricks and Harmworth in the Court of Appeal, and then of course the House of Lords decision there at tabs 27, 28 and 29 of the authorities bundle are very well known, and I'm sure, my ladies, you've read them for the purposes of this hearing, but I'm sure you've probably had occasion to read them on many previous occasions. I'll come to Benedico in a minute, but perhaps as I've dealt with BMBF, let me then just go to Tower M cashback. That, of course, is a case upon which the revenue here rely significantly to say that some different conclusion should arise to the conclusion that I have already expressed. And Tower M cashback, the Special Commissioner's decision is at tab 33, but I think we can probably just go straight to the Supreme Court at tab 36. It's page 478 of the bundle if you wish to turn it up. And there are some indicated passages, in particular on page 505. So, just to, without necessarily going through all the huge detail of the case, but of course one of the issues was that the software that was being sold there was not supported by any valuation in terms of establishing the correct price or what was paid for the software. And at paragraph 71 we see that Lord Walker says in commenting about matters, says the fact that these errors and omissions were made and apparently caused no concern emphasises the extreme unreality of selling the software rights in bits when they were parts of a closely integrated system designed for a specialised task. To my mind, it's only a little less unreal than for a syndicate which owns a racehorse in undivided shares to decide 48 hours before the big race to partition the animal so that one member takes the head and neck, another the off-hind leg, and so on. A further indication of how little practical importance seems to attach to the division of the software rights and what they were to earn is that the reader of the information memorandum relating to the LLP3 has to get to page 42 if he gets that far before learning that the rights in the call centre interface, itself mentioned on page 12, clearing fees.
If we go back for a moment to paragraph 41,
In the, oh yes.
Lord Walker refers to BMBF and what Lord Nichols had to say. He says the passages are well known and won't try to summarise them, which, to my mind at least, means that he's applying exactly the same principles, but he's taking what Lord Nichols called a realistic view of the facts.
Well, he's referring
is he enunciating any different principle?
Well, he's referring specifically, of course, to the bit in BMBF under the Ramsey principle,
yes.
Whereas what I previously referred to, of course, was the basic approach that the House of Lords endorsed in BMBF as to what it is you're looking at to assess. So you're asking yourself, what did the person get and what did they pay for it? Mm-hmm. And obviously you may want to take a realistic view of the facts as to what somebody gets and what they paid for it, which was precisely my point in starting with paragraph 71 to illustrate how in Tower End cashback, what Lord Walker describes as completely unreal as to what it was they were buying. And as he goes on, I was going to come to at 72, he says, for these reasons, I respectively consider that the judge, although correct in his view that market value is not determinative, and also correct in thinking that the Special Commissioner had used unnecessarily colourful and contradictory language, was wrong to dismiss as sweepingly as he did the Special Commissioner's scepticism about the valuation of the software rights. That, I say, is just not present in the case that you are looking at here in terms of London Luton. It was they weren't buying a hind leg of a horse. They were buying a property for which there was a specific development proposal which had been well worked out to be sold to the market, which was valued on a basis that was supported by the expert evidence as an appropriate way to value and arrived at an appropriate price that the market was prepared to pay, the 80 or however many investors were prepared to pay, based on the financial information that they were providing. Now that is the context that we're looking at. And of course, what Lord Walker's looking at in Tower End cashback is he is applying a realistic view of the facts as suggested by the House of Lords in BMBF. He's looking at, realistically, what did they get and what was the price they paid for it?
Yes. I mean, to pursue the equine metaphor, HMRC's cases, they're not just buying the horse, they're buying the saddle and the riding pinks and the hunting pinks as well.
Well, my lord, if you could just elaborate. To be able to buy a hotel, and there was acres of evidence about this in the first tier tribunal, to be able to buy a particular hotel of a particular brand, in this case Ramada Encore, you have to put in place the type of hotel in which that business can be conducted. You can't, as I put it to the first tier tribunal, is no good building a Dorchester at Luton Airport, because it's just not the place where anybody who wants to stay in a Dorchester is going to go and put up for the night, even if they're flying from Luton Airport the following day. Or at least, even if they are, you're certainly not going to attract enough business to make that a worthwhile proposition. So you have to have a hotel of a type to a brand that will work and which will work profitably at an airport like Luton. And that, if you read the information memorandum, that of course is what a lot of it is all about. The nature of the location and the type of hotel that can be appropriate. And I'm sure, my lord and my ladies, if you stayed in a variety of different hotels, whether it's Premier Inns, Hilton, there's a sort of Hilton lower type brand, Holiday Inn or whatever, you'll know that they are all done to a specific type. So it's no good converting the hotel into, so we've now got a sort of something that was a flight training centre, but is now going to be used as a hotel. Yes, but what sort of hotel is it going to be? Do they need, what sort of size rooms do they need? What sort of balance of rooms do they need between single and double and so on? These are all aspects of putting together a project to provide a functioning hotel that can be used. The allowance requires that this conversion ends up with a building that can be used. And that means it's got to be designed to a specific requirement that fits both the location, in this type, so Luton Airport, and the sort of people who are going to want to stay overnight at Luton Airport before flying, or maybe just want to come in and have a drink in the bar or something like that, and is going to have a certain guaranteed amount of occupancy. So all of the then hotels and who did all the financial work to work out whether or not this was going to be a viable proposition. You've got to have a viable proposition. If you don't have a viable proposition, you're not going to meet the statutory test, or at least you might meet the statutory test on day one, but you've got to keep this functioning for 7 years. Otherwise, you're going to lose all your tax incentivized investment because it'll be withdrawn. That's one reason why the brand changed from ultimately from Ramada to Holiday Inn, because after operating Ramada, due to the fact that I think it was a Hilton had opened, another hotel had opened close by, it had impacted the viability of the Ramada brand hotel that had been built. So they decided the way to change, to continue this hotel business successfully, was to change the brand from Ramada to a Holiday Inn. But you've got, what you're realistically asking is, what did you really buy and what did you really pay for it? Here, what they bought for was a project which was going to produce and did produce a Ramada brand hotel at the end of the day, and to the extent that that all needed to be fitted out in terms of fixtures and fittings, getting in the linen, the cutlery, the china, all that stuff, that was all subject to an entirely separate contract, which was not claimed for BPRA. The BPRA was claimed for the Cannock's obligation to produce a building from a flight training centre into a hotel which could open as a Ramada brand hotel. It's no good building a hotel to the sort of requirements of a Ramada hotel. So you can't sort of go round Ramada hotels and think, send somebody round, we'll have a look in how they organise a Ramada hotel, and that's what we'll do. And then, of course, you get to the day of opening, and Ramada says, "Well, we're not going to brand this hotel." I mean, you have to, these are things that you have to have absolutely clear ideas as to how you're going to achieve what the statute requires you to do, which is to produce a functioning building that will carry on a successful trade, or certainly at opening, and then aim for 7 years, because otherwise your tax relief is going to be withdrawn anyway if you sell or it ceases to be a qualifying building before the end of the 7 years. So that's the nature, that's the type of thing that the statute requires. And in terms of BMBF and Tariff cashback, what it requires is a realistic view of what did you buy and what did you get, and for what price. And I say that we spent the money entirely on the development obligation. We bought the building, we got a hotel, and we operated it for 7 years. And as I say, that I say is the end of the story. I've taken you to paragraphs 71 and 72. In over the page, this is back in Tariff cashback, just a note in relation to 506 and 507, where there are passages lined. that really also emphasises the way in which this was financed in the Tower cashback case. And my learned friend, Brimley Stockham, I think, took you to some of these passages, and it cropped up a lot in the revenues submissions about, so in particular at the bottom of page 506, in this case there was a loan, but there was not in any meaningful sense an incurring of expenditure of the borrowed money in the acquisition of software. White went into a loop in order to enable the LLPs to indulge in the tax avoidance scheme. Despite the shortcomings in the decision, the Special Commissioner was right in his conclusion in paragraph 138, quoted in paragraph 56 above. If we just go back to paragraph 56, we can see that what 56, the Special Commissioner, what part of his decision is being endorsed there, and that's on page 501 of the authorities bundle, and we see there 56, the Special Commissioner's conclusion on the expenditure point, so far as it is to be found in a single paragraph, is probably to be found at paragraph 138. The question that I have to address, therefore, is whether it is appropriate to say that capital expenditure of the gross figures has been incurred when the seller has filtered back 75% of the price to the investor members of the LLPs via the cosmetic banking chain, when the reality is that there is a great likelihood that a substantial portion of the wholly uncommercial loans will eventually be waived, and when in the meantime any partial repayments of the loans will be liable to be made on an entirely contingent basis. And when I address that question by looking at the legal reality of what has occurred and at the money movements, rather than looking fixedly at the discredited labels attached to the transactions by the parties, I conclude that the gross capital expenditure has not been incurred. Well, we know in our case the expenditure has been incurred. Yeah. So I say what one gets from Tower cashback is firstly that there was certainly underlying it an issue as to whether all of the expenditure claimed had actually been incurred at all, given the nature of the financing loop that had been created. But in any event, insofar as one was looking realistically at what had been bought and what was paid for it, there was no underpinning, as we have in our case, as to the correct price that was paid, and that they are fundamental distinctions between what we have in London Luton and what was being looked at by the Supreme Court in Tower cashback. And then the third case that I'll just go to is the Benedico case, which is at tab 23 of the authorities bundle, starting at page 130. My learned friend Mr. Macklem took you to this morning and drew your attention to one or two parts of it. I will not spend a lot of time on it. Mr. Macklem said that this was not really a comparable transaction to what we're looking at in London Luton, and which I respectfully disagree with him. Because if you read the first 3 lines, two and a little bit lines of the head note, the taxpayer company was incorporated for the purpose of carrying on the trade of hiring out an oil rig. Well, of course, we weren't trading, we were carrying on a property investment business, but we bought and invested and converted the building to let it out, of course. The contract for the construction of the rig was placed in 1969, so it's exactly the same. Benedico was doing exactly what we were doing. It was going to a shipbuilder and saying, I want you to build me a rig, or to a particular design, no doubt. And it may be that the shipbuilder had done all manner of things to sort of work out exactly what type of rig you might need for whatever jobs or letting out that Benedico might want to do, before he actually quoted or tendered for the job to build this for Benedico. But in exactly the same way as Cannock, in our case, put together a proposal for converting Blush House into a Ramada Encore hotel, In exactly the same way, the shipbuilder in Benedico was tendering and undertaking to build a rig that would be suitable for Benedico's requirements to let it out. Now, an obvious point to make from our side in relation to Benedico is that the statutory language with which it was concerned was only the words on the provision. Mm-hmm. On the provision. So when the House of Lords say, well, on the provision can cover and have both a broad meaning, which would include financing costs, and a narrow meaning which doesn't, when Parliament specifically enacts a allowance which extends to expenditure on or in connection with the identified object, in this case converting a disused building into a functioning, useful building, then I say, of course, it must extend to such things as financing costs. We're told that the word on covers a number of things in terms of travelling, so transport expenditure and the like. And my learned friend, Mr. Macklem, I think suggested, I obviously haven't had the benefit of the transcript yet, but I think if I understood him right, he said, well, in connection with covers things like surveyors and architects' fees. No, it doesn't. I say that's covered by on. If you have to use a ship's architect to design the ship that you want or the rig that you want built, that is part of your expenditure incurred on the provision of the rig, assuming that the costs of his architect's services are capital expenditure. Otherwise, what are we saying? That on the provision of the rig is just the nuts and bolts that go into it, rather than the architect's drawings and the like that have to be produced to be able to deal with this, or the managers who have to manage the in some way the backroom support needed for putting together a rig. I don't know, but I say that on itself covers a wide variety of things.
So, Mr. Gammy, it may be yes. On the provision of, which is different language to what we have in 360.
Well, my lady, no, of course it's different words, I accept, but no, I say it's not different in terms of what it's aimed at. The Capital Allowances Act, in terms of buildings allowances, has always talked in terms of on the construction of rather than on the provisional. And I'm sorry, it's now slipped my mind, but there is a case that says that on the provision of for machinery and plant means exactly the same as on the construction of for an industrial building, or it might be the other way around. An industrial building case, it's the same thing. So in either case, yes, the choice of words between construction and provision is merely reflecting the different nature of the item. Here, you're obviously not going to construct a building, because the whole object of the allowance is that you start with an existing disused building. So you're not going to construct it. So the words conversion and renovation, I say, convey exactly the same thing in terms of what it is you are giving allowances for, in exactly the same way as if you talk on the provision. My apologies, my lady. I wasn't sure whether you...
No, I just think there may be a distinction, because on the provision of a rig clearly covers more than nuts and bolts, covers the money you have to spend to get the rig. I'm just pointing out that the legislation in this case is slightly differently worded. It's on or in connection with the conversion, but not on the provision of the, for example, the converted building.
I understand the point you're making, my lady. My submission is that it's no different, because what you're doing, when you talk about on the provision of machinery and plant, that's because the nature of the thing the machinery and plant that you are providing is the way in which you describe it. In the same way as when you talk about on the construction of an industrial building, you're talking about what, all the expenditure that is necessary to construct a building, which would include, in my submission, things like architect's drawings, surveyors, all that sort of quantity surveyors, all that expenditure. Here, the nature of the thing that is qualifying for allowances is taking an existing building and converting it into a useful building. And I say that is, although it is necessarily different language because it's describing a different thing, taking an existing building and converting it rather than building it from scratch, I say it conveys exactly the same scope or intention as to the nature of the expenditure that falls within those words that qualify as on, and then when you add to that the words in connection with, it by itself indicates that it's going beyond mere or all the things that you'd ordinarily encompass within a conversion or renovation of a building to other things as well, such as financing costs, as we saw in Benedico.
Well, it's not that difficult to think of things that might well be incurred in connection with conversion of a building, which are not incurred on the conversion of the building. I mean, for instance, if you need to appeal against refusal of planning permission and you spend a lot of money on a planning inquiry to get the permission which allows you to build, you're not spending the money on the conversion, it's preparatory to the conversion. Or if the Section 106 agreement requires you to make a contribution towards highway widening or something like that, you're not spending it on the conversion, but it's in connection with the conversion. So it's not quite the same as buying an oil rig.
No, I would not, my lord, I would not disagree with you on that. I mean, of course, there has to, there has to be some proximity between the expenditure and the object of the expenditure, if I can put it in those terms. But if you're talking about surveyors' fees, or let's take architects' fees, because I think so you've got to have an architect who's going to work out how all these bedrooms are going to be organised around what was a flight training centre with a huge great atrium and space and the like. That, I would say, falls within the category of on, because that is fundamental to what it is you've got to do to it. But I agree with you, I think I can agree with you, that if you're talking about, there has to be some planning appeal or whatever, that may be more removed from the conversion, or if you like, preliminary in some way, to merely to fall within connection, but it would still be in connection with, within the meaning of those words, in my submission anyway. Why would it not fall? Because it is part of your total expenditure in bringing this property. So let's just go back to the purpose of the relief. The purpose of this tax incentive, or this allowance, 100% allowance, is in certain designated areas to convert disused buildings into useful buildings, and you have in the authorities bundle right at the end, I think it's tab 61 or 61, 62 and 63, you have three documents. You have the consultative document. The allowance was first announced in 2003. It wasn't enacted until 2004, and in 2005. In 2004, there was a consultative document which sort of set out what it was that the government was trying to achieve. But then there was what's called a regulatory impact assessment. That is actually presented to Parliament at the time of the budget when the legislation is produced, and then there were notes on clauses. Now, they're there, my lord, for your review if you wish to look to I say that what is absolutely clear from the formulation of this incentive was that it was designed for situations where it was not commercially viable for a disused building to be converted into a useful building, because the costs of doing so meant that it was not a viable investment proposal. I think that's absolutely clear from the background material. So the reason why a tax incentive is being given under BPRA is precisely because without some public funding in the form of tax relief, these buildings would just sit unused indefinitely. And I mean, the Blush House had remained, I think, unoccupied for a number of years before Cannock had actually built up a proposal that it could take to the market to raise the equity. So that's a sort of, and of course, there's no point devising a tax incentive unless the people who are going to use it are people who've got the tax capacity to use it. I mean, I hope that is obvious. So the fact that it's marketed to high net worth individuals, I say, is neither here nor there, even though my learned friends like to point it out that this was high net worth individuals getting some great deal that saved them tax. That was precisely what the incentive was designed to do. Now, I appreciate that that doesn't necessarily answer any questions necessarily as to what is on or in connection with. But when you look at Benedico and you see that the words on, certainly on the provision of machinery and plant, persuades at least one law lord that covers financing costs. But otherwise, you've got the additional words in connection with. I say that that's a strong indication that that's where one can look for the nature of in connection with as opposed to on. And there are two other features of Benedico that I just mentioned before we leave it. The first, of course, is what my learned friend Mr. Macklemster points out about the concerns by some of the law lords, that this could all be exploited and so on. It's also evident, I think, from Lord Helsham's speech, that one has to look at the policy of matter to decide what's covered. And I say the policy of the matter, because they talk about what is the policy of giving 100% allowance for expenditure on the provision of machinery and plant. Well, in exactly the same way, if you look at the policy of the original 100% allowance for machinery and plant, why don't you look at the policy for 100% allowance for BPRA? I say quite obviously that's a relevant consideration for the House of Lords in Benedico. Why would it not be a relevant consideration in deciding on the BPRA in this case? But then, one other point I just draw your attention to in Benedico. The first is on page 135. This is in Lord Helsham's speech, where just above the letter F, he says, it follows that the only question in dispute is whether the fees and interest were items of expenditure on machinery or plant. This depends on whether a narrow or broad construction is to be placed on the words. The taxpayer company contended that the words include all items properly incurred for the provision of the ocean tide, which would include the cost of financing the payment for it. For the Crown, it was argued that the only expenditure on the provision of the ocean tide was in effect its price, and that the commitment fees and interest were not expended on the provision of ocean tide within the meaning of section 41, but on the provision of the money to pay for it, and that this is the purpose of the subsection, to be regarded as a distinct and separate operation. So they're drawing a distinction between the money you raise to pay the price and the price. But of course, the money that you raise to pay the price is obviously in connection with the provision of the item for which the price is to be paid. Why else do you raise money but to pay the price? And as he then goes on to say, in my view, the actual words of the statute are capable of bearing either construction according to the context in which they're used. But at the end of the day, I agree that they bear the narrower of the two meanings, that is that contended for by the Crown. In other words, you get relief on covers the price, but it doesn't cover raising the finance to pay the price. I say that is in connection with it. And then Lord Keith, no, sorry, Lord Russell, makes a similar point in his speech. This is on page 141, just above the letter G. He says, the point was made for the taxpayer company that if the provider of the plant borrowed for working capital and incurred as a result liability for interest and perhaps a commitment fee in respect to such borrowing, these liabilities would be reflected in the price paid, the whole of which would qualify as relevant capital expenditure by the company buying the plant. That is so, but I do not follow the conclusion from that fact. It does not appear to me that to be an alternative to borrowing by the purchaser, the supplier's price would reflect the whole cost to him of supplying the plant, including overheads, interest on necessary borrowing, or on commitment of working capital, and a profit element. The whole price being subject to a perhaps competitive market. I am not able to see how the build-up of the supplier's price can have any relevance to the problem raised in this appeal. So both Lord Russell and Lord Hailsham specifically approving the argument being put by the Revenue, focus on the price. That's what you pay, and what you get is what you get for the price. In Benedico Limited got a rig which it duly leased. The LLP, in our case, paid a price for the development of obligation of Cannock for the project that Cannock had put together, which produced a converted building, fully functional, operational as a Ramada Encore hotel. And I say that is the end of the story, and that is the basis upon which I have put the taxpayer's case before both tribunals. The first tier tribunal, for the reasons identified by the Upper Tribunal, chose to focus on how the developer had spent the price. If you want to look at it, so I say, and as I put it in the Upper Tribunal, the question is what do you get for your money? And what LLP got in this case was a converted building into a Ramada Encore hotel. That's what it got for the money that it paid. If you want to look at it from the perspective of the developer, it's not a case of how did he spend the money. At the most you can say is what did he do to, what did he have to give to get the money in hand, which he then spent. In, of course, BMBF, what BGE got for the money was to sell the pipeline. Here, what Cannock got, or what it gave to get its money, was the project of Blush House conversion into a Ramada Hotel, Encore Hotel, for which it made a profit. It wasn't paid a fee. It made a profit from the development opportunity that it had identified, built up into a proposal that could be sold to the market, was sold to the market for its market price, and which it then saw through to completion. Now, I say it made a profit. Of course, we don't know where it made a profit. It might have made a loss because it was a developer, it was a trader. It incurred a lot of expense, no doubt, before it actually got this proposal to the market, for which it was paid nothing, because what it was aiming to do was to make a profit by selling it to the market at a price that the market would pay. And that's what it did. And it then saw the project through to completion. And of course, it took the risk that something might happen, which would mean that what it had been paid on the 25th of March 2011 actually proved completely inadequate for the costs that it had to face, both in terms of what it had already paid before it actually got the thing onto the market, but also in terms of what the way in which the development turned out. I think it was Mr. Grimsby Stockham said, well, you know, you have to assume, he was talking, I think, about the capital sum, you have to assume that actually there's some complete disaster or something at Luton Airport. You know, this is found to be on contaminated land, and so actually the bank can't sell for even the 8 million that the Edward Simmons non-trading valuation suggested, and you know, therefore it might not get its money back. Actually, for those sorts of eventualities, it's Canada that bears the risk in many ways, because it has taken on the obligation to deliver the project at the end of the day to the LLP. And indeed, as at the hearing, there was evidence that, for example, in relation to the conversion, I think, of a disused police station somewhere up in Yorkshire, I think it was, I can't remember the precise place, the place had been found to be riddled with asbestos, which then, of course, gave the developer significant financial issues about how it dealt with it. It had been paid to deliver this converted police station, I think it was, and of course the costs of doing so significantly outweighed what had been paid for doing so. So there's an element of risk taken on by the developer. But even if there was, when I say no risk, even if the risks were small.
Well, the risks have been partly laid off on the basis of a design and build contract at a fixed price.
To an extent, that was the subject of cross-examination and evidence before the first-tier tribunal. Certainly, it will look to limit its risks, as any businessman conducting a development business would seek to do. But there's nothing to say that if the market will pay $15.5 million to buy the property based on financial information as to the trading prospects of the hotel, and therefore that's the way in which these things are valued, and that effectively stands up to critical examination for the first-tier tribunal, based on Edward Simmons' valuation, the figures that have been given by then Hospitality, etc., and the expert evidence Mr. Harper gave before the first-tier tribunal. And who's to say that they can't make a profit? Is there some are they to be condemned because they make a good profit from the opportunity that they have identified? Of course, that, when I say that in itself doesn't answer the question of what qualifies for BPRA, except, as I say, that was the price the market was prepared to pay to get this building and have it converted to a hotel, for which Canuck took on the obligation. And I say that is the amount which qualifies for allowances. It doesn't matter how the vendor constructs its price. In this case, it was a market price determined essentially by what debt facilities they were able to negotiate and what the market equity investors were prepared to pay, with the benefit of a tax incentive that the Act allowed. But nevertheless, that I say is what they're entitled to get their allowances on. The price they paid for what they got. Now, the first-tier tribunal, as I say, for the reasons that we submitted to the Upper Tribunal and the Upper Tribunal largely accepted, determined that one had to look at or analyse how the developer had spent the money rather than actually what the LLP had got for the money that it had paid, the expenditure it incurred. And the Upper Tribunal largely accepted that, but we say went off the rails a bit when it came to the intercreditor deed. And you have in our skeleton argument and in the revenue to apply skeleton a series of arguments about how the intercreditor deed should be construed.
Yeah.
The intercreditor deed is at tab 3 of the supplementary bundle, starting at page 141. And of course, what you have is money that has been raised by the LLP through equity and debt. And of course, some of that money is going to go off to Chainridge to pay for the freehold of the property. So that amount of money has to go off in that direction, and no claim for allowances is made on that. But of course, from the perspective of both the bank and the LLP, they are both essentially creditors in relation to Cannock, which has taken on the obligation to convert this property into a Ramada Encore hotel, or to do the works as identified in the development agreement, and to then hand over the building in its converted state. And of course, that means that there has to be some agreement, certainly involving both the bank and London Luton, as to how the respective obligations, how they're going to be managed as between each other. And that's what we say the intercreditor deed is doing. But of course, by the time this deed is, even though it's all on the same day, at the point at which this is done, the money has been handed over, the expenditure has been incurred, the money has been handed over to OVL for its obligation, and we say that the intercreditor deed does not involve any more obligations by Cannock to the LLP in terms of what the LLP is getting. The LLP has got the obligation it wants, for which it has paid an expenditure incurred under the development agreement, and the fact that then there has to be, because OVL is the one who's sort of sitting, who's been paid and is sitting, certainly so far as the development sum is concerned, is sitting there with the money, there then has to be some way in which the obligations are regulated as between the co-op bank and London Luton, and that is what the intercreditor deed is doing. And indeed, there were in fact 3 intercreditor deeds. So there was an intercreditor deed, I think, dealing with the hotel company and the loans there, but there was also another intercreditor deed relating to the liabilities of OVL to London Luton, BPRA and the bank, which is not in the bundle. If your lordships, I think Lady Justice Falk, you asked about this, we can arrange for copies to be provided if you would like them, but of course they're again a similar effect, seeking to regulate the relationship between the co-op bank and London Luton BPRA LLP.
So it relates to the LLP's liabilities, I take it.
It's the liabilities of OVL to.
No, that's the one that we have got in the bundle.
I think this is different. There were definitely 3. I thought I had printed off.
Okay, I would quite, personally myself, quite like to see the one that regulates the LLP's liabilities to the bank and OVL respectively.
I'll arrange for you to have a copy of the intercreditor deeds, so that you can see that. but we say at this point in time, broadly speaking, what it is doing is regulating the obligations of the creditors, the two creditors' positions. And unsurprisingly, of course, you always find that Co-op Bank comes out top. I mean, you know, almost. Have you ever seen a deal where the bank hasn't come out on top? Of course, deals involving more than one bank can raise issues as to who's going to come out on top, or whether there's going to be a tie for the first place. But broadly speaking, here, of course, the Co-op Bank is going to protect its position to ensure that it has first bite of any value or money or assets that are available to secure what it has lent into this arrangement. And as I say, we set out in our skeleton argument where we see how we consider the intercreditor deed, and it does not affect the basic situation that the money, the expenditure that has been incurred on the development obligation, and that is the end of the matter. Let me just go off, because I think at this point I should address some of the points that have been made in relation to both the capital account and the residual sum, because broadly speaking, I say my answer on both of those is the same. I mean, they are essentially part of the developer's profit that it has made from putting together this project and selling it into the market on the basis described in the information memorandum. Now, as I understand the revenues argument as they now put it in relation to the capital account, what they say is, and this is what my own friend said yesterday, it's at page 41 of the transcript, lines 6 to 12. He says it's not conceptually possible to say on day one that the capital account is incurred on or in connection with the development, because it might return to the cooperative bank without any corresponding obligation arising on the LLP to reimburse or repay OVL. So, as I understood his argument, you have to, and of course this assumes that you can look beyond the development agreement and into the intercreditor agreement to say that because 2 million has to be put into the capital account, that means that you've got to question whether or not that is expenditure incurred on or in connection with the development. And they say it's not, because on day one you can't say with absolute certainty, I think that's possibly a way to put it, that it will end up with the Cannock. It might go back to the co-op without Cannock having any corresponding obligation against the LLP to be reimbursed or repaid it. Now, I thought about this in light of my learned friend's submissions. I think it's a sort of slightly different, struck me as a slightly different emphasis, because I don't think for the Upper Tribunal, as I recall it, that there was sort of quite the emphasis that this was something that had to be determined on day one. It didn't prevent him at a later stage in his submissions saying that it was circular and self-cancelling because, as we know, it went back to the co-op in whenever it was, February 2014. He can't have it both ways. He's got to look at it on day one, or if he's going to look at it in February 2014, he's got to look at the finding of fact by the first-tier tribunal. But when it went back to the co-op, there was a corresponding obligation arose the increase in the developer loan agreement, so that in fact, although the money, the co-op withdrew the capital account, that gave rise to a corresponding debt from the LLP to the to Canada, which was ultimately repaid in, I think, finally in 2017, refinanced, of course, with NatWest Bank shortly after.
Can we just take it in stages?
Yes. Of course.
This part of your argument, I think, assumes that you fail on your ground one. So we are entitled to look, or we should look,
Yes.
at the intercreditor deed.
Indeed. So
The
yes.
next step in HMRC's argument, I want to know whether you agree or disagree, is if we are looking at the intercreditor deed, are we looking at the position on day one, or are we looking at something else?
Well, I certainly, in relation to the capital amount, I think we're looking at things on day one.
Day one.
Although, as I say, I think it seemed to me his later submission that it was circular and self-cancelling by looking at what happened later was inconsistent with that.
Well, I understand the inconsistency point, but one or other of them might be right, so which one?
Well, of course, I say both of them are wrong.
Yeah.
Because I say that the capital account doesn't give rise to the consequences that he wishes to say. But whatever, it lets assume for the moment that his construction of the documents is right. What he's effectively saying is that if there was an event of default, Cannock would repay 2 million of the purchase price. Now, this, I say, goes to the sort of to the sort of commerciality of that construction. I mean, my learned friend was sort of very keen to say that this was all a commercial arrangement because it sort of strengthened co-op's hand, as if co-op's hand really needed strengthening, given that it had security coming out of its ears, really all it was concerned about was whether it got its money back, for which it had perfectly adequate security on the Edward Simmons valuation against the property. But why would Cannock, having sold this property into the market at 15.5 million, why would it turn around and effectively rebate 2 million of the purchase price to the LLP? I mean, they noted, I think my own friend noted, that how broad the events of default were under the co-op loan. One can, so if the LLP thought, hello, this is a good idea, what can I do? I can manufacture an event of default, tell the bank to recall the capital account, and I'm 2 million better off. It doesn't make it. I find that very. I just don't see the commerciality of that. Cannock has put together a project, sold it into the market for 15.5 million. Its loan, it's sort of part in the financing. It's lent 1.3 million by way of developer loan for this, and it's deposited 2 million of its profit to secure part of the co-op's loan. But that on the Edward Simmons valuation, even on a situation where the whole thing has to shut down and you just sell the property, the Edward Simmons valuation ensures that Cannock gets its money back. So why would it want to donate or sort of remit 2 million of the purchase price?
Can you help me with the £8 million valuation by Edward Simmons? I thought that was on a sort of something's gone wrong, but it's not asbestos and it's not it's not a complete disaster. So there is a disaster scenario that isn't the ES valuation, isn't there?
Yes. So the ES valuation provided 3 valuations.
Yeah. And you're talking about the lowest
8 million.
one.
So even in the worst case scenario, of according to the Edward Simmons valuation,
Okay.
you've still got enough security for Cannock to get its money back.
Well, the worst case scenario on that valuation assumes a completed hotel, though, doesn't it? It doesn't assume a half-completed building site, for instance.
No, but so supposing Cannock, let's just think, supposing Cannock went bust or something like that.
Well, if a contractor went bust.
So a contractor went bust, and so there was a big issue about what would happen. Of course, if the property was sold, I mean, from the LLP's perspective, the last thing it wants is the property to be sold because, of course, you get a recapture of all the allowances.
Yeah.
Yes, so Cannock decides, well, I can't go on with this, we've got to replace me or something like that. Yes, that was my own friend's. Just to be clear, of course, Cope gets its money back on a disaster scenario because it's got the 2 million capital account deposit anyway, but it's got more than enough security to cover its whole lending, whether it's rated as 5 or 7 million. But I was thinking also that Cannock itself, to the extent it's a lender into it, would have the potential of getting its money back. Why, in these scenarios, would Cannock agree, or why would it envisage that it should actually rebate 2 million of the purchase price to equity investors who put up their money on the basis that this is a risk? When I say a risky venture, this is, that equity is there to assume risk. And here we're just saying, out of the goodness of its heart, although as I say, I'm going to come on and say why we don't agree with the revenues construction. But you're saying on day one, because there is the potential for Co-op to draw down on the capital account and for Cannock not to be able to get that money back from the LLP, therefore it's not incurred on or in connection with the development. The commercial, as I say, I cannot see any commercial reason at all for Cannock reimbursing. That's what effectively amounts to on an event of default. If the revenues construction is right, effectively Cannock has agreed to reimburse 2 million. Of course, when you read the information memorandum, it doesn't say anything about that at all. It says that if the capital account gets drawn, then that becomes a debt due to the to Cannock as the developer, and that makes perfectly rational sense because this is part of Cannock's profit. It can sell it into the market for 15.5 million. Why is it going to give 2 million back? Because there's an event of default. I don't follow the commercial basis for that approach. No reason at all for Cannock to have agreed that. And of course, what we're talking about is a scenario which obviously everybody hopes is not going to happen at all. In fact, didn't happen because we're told by the first tier tribunal that when the capital account was drawn down by Co-op, it became a debt due from the LLP to Cannock, and Cannock was eventually repaid back. So it doesn't match the actual facts. But my learned friend says on day one, you have to say if there is any scenario that you can construct, which means that the money might not end up with Cannock, even though it has already ended up with Cannock and been deposited by Cannock, then that's not incurred on or in connection with the conversion of the building, even though that 2 million is part of the price that's been paid for Cannock's development obligation. I don't understand. So, I have, by going into that, I've dealt with two aspects. If you remember, my learned friend had three ancillary arguments. The first one was that there was commercial reasons why, for the whole arrangement, and at the same time that there was no commercial reason for the upfront payment. Just as a matter of note, the capital account arrangement derived from a transaction that was done with the Royal Bank of Scotland in a previous deal, where I think it emerged from negotiation to sort of persuade RBS to lend in the particular situation.
Do we have some findings of fact about that?
It was
Or are you
certainly
just telling us?
It was certainly part of the evidence, and it's in. It may well be in one of. I can check whether it's in one of. It'd probably be even in Mr. Tracy's or Mr. Lewis's witness statement. It's there, but it was certainly dealt with in the evidence before the first-tier tribunal. But we know that in this particular case, they've been through at least 4 other banks and turned them down. And of course, we are dealing with a situation in 2011, immediately post the financial crisis, where financing these sorts of deals was by no means straightforward. So I think the evidence was, and as I say, we can turn it up precisely if you wish to see it. So, my lord. I'm told it. Thank you. My own friend, Mr. Brenner, says it's at paragraph 65 of the first-tier tribunal.
Thank you.
Decision. Yes. So this was sort of off when I say put forward as a basis for persuading the co-op to lend as a sort of starter, as we saw. So the suggestion did come from Canet. That's perfectly true, I think, on the evidence, but it was based on what had been done in other deals. And the fact that one of the people within Co-op Bank who'd not been involved in the sort of preliminaries of dealing with this deal didn't understand what it was all about, I say is neither here nor there. Mr. Matthews, who gave evidence, who was the person involved at the Co-op Bank dealing with these things, he understood it all. He explained why, from the Co-op Bank's point, there was a difference between lending 5 million or lending 7 million with the benefit of the capital account. In the end of the day, the co-op agreed to lend 7 with the benefit of the capital account. But if looking at it from the perspective of 2 million going into the capital account, this was sold into the market for 15.5 million. You can't just drop out 2 million. You've got to fund 15.5 million. So it's no good raising 13.5 million. So on day one, to say that there's no commercial reason for the upfront payment, you needed that amount of debt finance to get the purchase price. As I said, the idea we're having funded that and got that money up front for the purchase price, why you just donate back 2 million?
Yeah, no, I think we've got this point, Mr. Gammy.
Sorry.
I think we've got this point.
I'm sorry, Lord Abdalska. The third ancillary point, I was just dealing with the 3 ancillary points. The third ancillary point was that Cannock had no beneficial interest or beneficial ownership of the money, to which I say that can't possibly be right, because on a multitude of other situations, even assuming that the revenues construction of the capital account deed is correct, there were multiple situations where Cannock would have got the money. And let us leave aside the fact that he actually did get the money, that it would have got the money. And I would have thought that if you have, if you deposit money with a bank, under which there are a variety of circumstances where you're going to be able to walk out of the bank with the money in your pocket, even if you need a very large pocket for 2 million, the reality is you have some form of beneficial ownership of that money, even if there is another contingency under which that money might not come leaving aside the fact, of course, that Cannock received interest on the deposits, and even if the interest was credited to the account, that would still ultimately come to, and did come to its benefit as and when it was withdrawn. So I say the ancillary arguments, there is nothing to them. So let me just deal with the main argument that if an event of default occurred and the bank withdrew the money under clause 3.5.3 of the capital account deed, then Cannock would have no right of recourse against the LLP. Now, my own friend pointed out to you that there is a clause in the co-op agreement, clause 10.31, he took you to it this morning, to say that the LLP won't increase its borrowings beyond that encompassed by the various documents, including the developer loan agreement. I say that tells you nothing because it merely begs the question as to what is the amount of the loan permitted under the developer loan agreement. So I say that takes you nowhere. And what we're talking about is what is the relationship between, what is the agreement as between Cannock and the LLP. That's what we have to focus on. My learned friend, of course, puts all the weight of his argument on the fact that there is a difference between clause 3.5.3 and 3.5.4 of the capital account deed. He puts the whole of the weight of the argument on that. And, of course, the most you can say about that is that it tells you in 3.5.4 that the developer loan agreement increases in those circumstances, but it is silent as to the consequences of a withdrawal under 3.5.3. So it is merely silent as to what would happen as a result. Of course, we know that there was a separate guarantee and security for that guarantee that had been entered into by OVL. And I think that my learned friend's construction has to rest upon the possibility that not only does the co-op just withdraw on an event of default under 3.5.3, but it also does not call its guarantee. Remember, we're dealing with this on day one, so we have to postulate circumstances that may or may not happen in the future. And of course, given that Cannock has guaranteed, given a guarantee in respect to these monies to the bank, we have to assume for my learned friend's construction to work, or his point about incurred honour in connection with to work, that not only does the bank choose to withdraw under 3.5.3 on an event of default, but it also does not call under its guarantee, because I say quite clearly, if it were to call under the guarantee, then in the perfectly normal way, Cannock would have rights against the LLP to recover that money. It's not that the agreements specifically say it can't. They're silent, and that's if one has to fall back on restitution or anything like that, rather than the normal situation where a guarantor pays in respect under its guarantee and then has rights of subrogation against the debtor. You'll have restitutionary rights for the very fact that it's silent about what would be the consequence of the situation where under the 3.5.3 no it doesn't tell you one way or the other as to what is the consequences of that event. And I have to say, my learned friend took you to certain parts of the Goffin-Jones in relation to contribution, but I had some difficulty in understanding precisely what the point was in respect of those sections of Goffin-Jones. It did not seem to me that this was a matter of contribution. It's a situation where somebody has guaranteed a particular debt and has been called to pay under its guarantee. But I think my learned friend's point must rest on the very fact that Co-op Bank just takes advantage of the event of default to withdraw the capital amount, but doesn't call under the guarantee, and that there isn't a sort of automatic situation where, having recovered the money under the event of default, that isn't taken to be to trigger the guarantee because formal mechanics of notice, etc., haven't been given. As far as I can recall, I don't think any formal notices or anything like that were given around 2013-14 when the capital account was withdrawn and then refinanced by NatWest.
One slight query here. When I think when we were taken to the capital account deed yesterday, there was some reliance placed on a provision in it saying that this document effectively governs the only circumstances when there can be withdrawals from the account. Yet if you look at the guarantee and the charge over the capital account which support that guarantee, of course that contemplates a release of funds from the account.
Yes.
Do you have anything to say to assist us on that? I mean, because what I think you're saying is that the revenues argument makes an assumption that the guarantee is not called upon, and I think you're implicit in that you mean called upon by taking funds out of the capital account.
Well, I think my learned friend's point was that there needed to be a sort of formal call under the guarantee, which wouldn't be needed just to take the money out of the account. If I remember the point he was making.
Yes, that was one point. I think this was a slightly different point.
Well, I'm not trying
about
to
3.6.2 of the capital account deed. And I'm just trying to understand how it is thought that all the documents work together. So page 164.
Yes, I have it.
Well, I'm just considering that with the guarantee and the security that goes with it.
You're thinking about 3.6.2, no?
Yes.
No withdrawals from the capital account may be made except as permitted by this deed.
So I suppose I'm asking, let's say the guarantee, that the bank did decide to call on its guarantee.
Yes.
And it's a limited recourse guarantee, and the most obvious funds available is that 2 million. What happens?
Indeed. Well, presumably it would be calling under the guarantee because it's an event of default.
Yes.
So then it would have the ability to withdraw under 3.5.3. Is that not right? And maybe I'm misunderstanding on Eddie, but isn't that?
I'm just not sure. I may have missed it. But the capital account deed itself says, one of the circumstances you can withdraw is when there's a guarantee call on the guarantee.
Well, I think the withdrawals have to be payments from capital account is under 3.5.
Exactly.
lady, I'm probably not following your point, and I'm not immediately recalling
Well,
what my own friend said. But
we're looking at 3.5 as apparently the only circumstances when a withdrawal can be made. So if the guarantee is called upon, under what provision is it 3.5.3?
well, I think, so suppose if there were an event under the guarantee that was not an event of default, as defined for these premises, there would be, when I say there would be a conflict between the two, presumably, because the guarantee would be saying, well, we can...
Right, okay, let's leave aside conflicts. Let's assume there is a clear event of default.
Yes.
Which could result in the call under the guarantee. My point is whether 3.5.3 has to be used for that purpose.
Well, when you say has to be,
well,
it's available. It's available, surely available to use because there has been an event of default. So, I mean, I'm not sure that the bank necessarily has to say, you know, I'm exercising my rights under 3.5.3. It would presumably, you know, serve whatever notice or whatever under the guarantee, or would tell Canic that it was, you know, calling under its guarantee, and then it would presumably just take the money out of the account. I mean, when I say the trickier, just looking at 3.6, we see it says no withdrawals may be made from the capital account unless the bank has received at least 3 business days prior to the proposed date of such withdrawal a notice of withdrawal signed by an authorised signatory of OVL from the account of the type to which the notice relates. I assume, I mean, it doesn't say so explicitly, but that must presumably only relate to withdrawal under 3.6.1, mustn't it?
3.5.1.
Sorry, 3.5.1.
Okay, and that might limit the effect of 3.6.2. But anyway, let's move on.
Well,
my basic point was only that the capital account deed its wording doesn't seem to tie directly to the guarantee.
No, well, I suspect
the guarantee and the charge.
I mean, one has to speculate a bit about these things, but of course, as we saw, as my learned friend drew attention, all of the sort of bank's documentation is just sort of standard documentation.
Well, the guarantee is this document isn't, but the guarantee
no.
is.
So it's just that the two may not have been perfectly tied together, you know, interlocking and so on. It's not.
But your argument on the capital account deed is relatively straightforward, isn't it? You start with 3.5.1. If a withdrawal is made under 3.5.1, it goes into OVL's pocket, and that's an end of it. If it's made under 3.5.4, it goes to the bank, but OVL has a corresponding right to an increase in the developer loan. So then we're looking at 3.5.3. 3.5.3 only applies on the occurrence of an event of default. So we need to know what an event of default is. We're told earlier on that by 1.4 that capitalised terms defined in the facility agreement have the same meaning in this deed. So we looked at the facility agreement. What is the facility agreement? It's an agreement by which the bank agrees to lend money to the LLP. So the primary obligor is the LLP. This then is a case in which money is used to pay the primary obligation of the LLP, and it comes out of an account in the name of OVL, leave aside beneficial interest for the moment. General rule, unless excluded by clear words, is that if a person secondarily liable pays a debt under compulsion of a person primarily liable for the debt, then the person who actually pays is entitled to That's the argument, isn't it?
My lord, yes, it is. But I mean, I also, you know, insofar as one wants to see, if you like, a further answer to the point that I was coming to. The point is that this is essentially dealing, the relationship you're concerned with is the relationship between Cannock and the LLP. Now, you, my lord, you've just explained in a very clear way how you know, you can look at them between the LLP as primary obligor and the Cannock as the person called upon to pay and therefore entitled to recover. But if one's looking to see what was agreed between Cannock and the LLP, one looks to the developer loan agreement. One doesn't look to the capital account deed. The capital account deed is silent on the matter. And when one looks to the developer loan agreement, we've already noted, my learned friend noted that this was a less formally formulated document. What we note from the preliminary wording of the developer loan agreement is that it talks about withdrawals, but it obviously can't mean every withdrawal that is envisaged by clause 3.5 of the capital account deed, because the first ones on 3.5.1 is OVL taking out its money and walking away with its money. So obviously the developer loan agreement, when it talks about withdrawals, that has to be understood in a particular way. And as we say in our skeleton argument, the obvious way to interpret or to understand the developer loan agreement is that it just says withdrawals by the co-op. In other words, when it says about adding to the developer loan agreement for withdrawals, it's withdrawals by the co-op, which means can be either under 353 or 354. It may be that whoever drafted this didn't actually see the need to add specific language into 353 for the reason that you, my lord, have indicated, that it would be obvious if there was an event of default and OVL's money was used to repay the LLP's liability, that Cannock would be able to recover from the LLP. And the mechanism that had been provided under the agreement for that was that it was added to the developer loan agreement, which was precisely what everybody had been told and what the Cannock and the LLP had articulated in the information memorandum. Why on earth wouldn't you take the information memorandum as an indication of exactly what the parties had agreed would happen in those circumstances, rather than the I would tend to describe it, bizarre circumstance that you postulate that in these situations where there's an event of default and no call under the guarantee, effectively Cannock rebates 2 million of the purchase price to the investors. Yeah. It makes no sense. So my lord, that's my answer in relation to the capital account. Why I say it does not bear the construction that my own friends wish to put on it, let alone the further question that they essentially raise by saying, well, you've got to look at this all on day one and then ask yourself the rather mind-bending question of, are there any circumstances in which this money might not get to the person who's been paid on day one, Cannock? That brings me then to the residual sum. And I say the residual sum is no more than the developer's profit. That's what the Upper Tribunal concluded. I say they were absolutely right to do so, because the development obligation had been sold by Cannock to the LLP for a price which enabled it to earn a profit. And as we saw from Benedico, when the supplier, so when the shipbuilder puts in a tender which says, I'll build you this rig to Benedico for X, and builds into that a satisfactory profit, maybe even an extreme profit, but Benedico decides that this is the builder that he wants to use and it's prepared to pay that price, then that is what the shipbuilder, or in this case Cannock, is entitled to walk away with. And as I say, it may not be profit, it may be loss, depending on how things turn out and how the rest of its business goes. But the fact it makes a profit does not mean that it's not part of the price that the LLP has paid, and therefore it's entitled to the benefit of allowances. So even if I'm wrong on our first ground, but broadly speaking, you look at what the price was, what the LLP got for the price, the converted building, and that's the end of the matter. Even if you can look at what some of the things that happened to the money once it had been handed over to Cannock, in relation to the capital account, for the reasons I've given, I say that was again an element of its profit that it was prepared to put on deposit as security for additional security for the co-op loan on the terms that we've seen, and in relation to the residual sum, that again was an element of its profit, which is neither here nor there in terms of determining the allowances to which the LLP is entitled, and is no more or less than that.
Well, I think HMRC's point is that, assuming you're wrong on your first ground, and that one can look through to the various, I'll call them contractual obligations, that OVL assumed to the LLP, the profit earned by OVL was a profit attributable to the provision of a variety of different things, some of which qualify for BPRA and some of which don't, and therefore HMRC say it is appropriate to apportion the gross profit between those elements of what was supplied that don't qualify and those which do. That, as I understand it, is the real point under this residual sum.
Yes, and I can see that, and indeed, my own friend Mr. Bremner, in a sense, will have to be, when I say addressing some more of those, he'll have to be dealing to some extent with what are the elements of the non-qualifying.
But assume that some qualify and some don't. What do you say about the apportionment argument?
So we're assuming, well, so there is obviously, my apologies, there is obviously an apportionment to be done insofar as the section 360B contemplates the possibility that expenditure can include both qualifying items and non-qualifying items. So, for example, if in constructing this hotel, the developer had to build some form of extension, and indeed that was part of one of the arguments that was before the first two tribunal, which didn't proceed, I think, into the upper tribunal, was whether or not some of the particular works that had been done, for example, I think on the roof, I think this might have been one of the reasons.
There was something to do with the car park as well, I think.
Was whether or not it amounted to an extension. And of course, in those situations, because the Act specifically contemplates qualifying and non-qualifying expenditure, that may be a circumstance where something that has to be apportioned between, or you have to decide what relates to qualifying and what relates to non-qualifying. So that's one situation. So I think the other situation, my lord, that you'll possibly have in mind, and my learned friends may have in mind, is supposing you've got some expenditure which is not non-qualifying in the sense of falling within section 360B3, but just doesn't qualify.
Yes, because it's not in connection.
Because it's not in connection with. Then I think, to that extent, I suppose you would have to have some form of, investigation as to what was properly paid for each particular item, because you know that of this payment that's been made, let's call it 100, 80 has gone on things that have qualified, and 20 have gone on things that have not qualified. And now let's suppose you've sold that for 120, so you've got 20 profit. You know, to what extent is the 20 that's gone into the non-qualifying things the right price of the 20? Or to what extent, and therefore, is the whole of the profit of 20 attributable to the 80?
Right. So you is this right? You accept that in principle, not on the facts of this case, but in principle, there could be an apportionment if what the LLP got for its money, if some of what the LLP got for its money fell outside the scope of BPRA.
Of BPRA, yes. Yes. And that would obviously be an investigation into what was the correct price for each element, I think. I think that's probably the way.
Yeah, thank you. That's clear.
Yes.
And in relation to the land in this case, which you obviously accept doesn't qualify, I think you're saying that none of the residual, what's been described as the residual amount, is on any basis properly attributable to that. Is that what you say?
Yes, we do say that. Of course, when I say the original, the position, as it's explained in the first tier tribunal, the position was that the whole of the development sum was paid for the development obligation, and that was the end of the matter. Because the revenue said, well, they couldn't possibly accept that in relation to the conveyancing costs of the land, no claim was made in respect of that element of the legal costs which the solicitors said was attributable to the conveyancing of the freehold. So that was accepted as a practical matter, but that makes no difference to the rest of the claim is actually entirely free of that aspect of non-qualifying expenditure. Right,
thank you. Is that what you want to say about the residual sum, or is there more?
No, I think, my lord, that's probably, I think you probably have our main points.
Yeah.
As part of the profit. As I say, the question of apportionment and some of those items, my own friend Mr. Bremner may have to say something about when he deals with franchise costs and heaven knows what else. So, my lord, I don't know whether you would like Mr. Bremner to start.
Well, I think so. We've got 20 minutes or so we might as well use them.
What I'm going to do is pick up the other individual items. So to deal in turn, first of all, the IFN promoter fees. I'll start there, if I may, with the revenues grant 3. Secondly, franchise costs, so that's the revenues grant 4. Thirdly, I may need to pick up a couple of points of detail on apportionment, so that will overlap with, I suspect, the revenues grant 2. You've obviously just heard from an friend, Mr. Gammy, on the point of principle there, but there are probably some more points that I will need to pick up on that. Those are the response points, and then my fourth topic, and last topic, will be to open the LLP's appeal on the licence fee. So that's LLP grant 2, and that's the menu for what I'll deal with in the remainder of today and part of tomorrow morning. So on topic 1, IFN promoter fees, we deal with those in paragraphs 53 to 68 of the response skeleton. Those submissions, they build on the more general as to the interpretation of the concept of qualifying expenditure that is set out in paragraphs 17 to 20 of the appeal skeleton. On the IFN promotion fees, if I may, I'll take it in 2 stages. I'd like to begin with 4 short preliminary points on the in connection with concept as it appears in section 360 capital D, which I'll then use really to frame those submissions. I'll do it with reference to the those points, as you can appreciate, I say generally applicable to each of the items under consideration without expecting them once. And then secondly, I've turned to the nature and the context of the IFA and promotion fees themselves, and I'll develop my submission that nothing in the revenues appeal discloses an error of will that would justify upsetting the conclusions of the tribunals below, that the fees qualified for BPRA. Now, I don't need to go any further than that, and I can and I do go further, and I will submit that the first tier was not just entitled, but indeed correct, to hold that those fees qualify for business premises renovation allowances. So the four framing points, if I may start with those. First of all, common ground that the interpretation of the statutory phrase in connection with the conversion, and if I may, I'll just stop with in connection with the conversion and use that as a shorthand for conversion, renovation, incidental repair, little a, little b, and little c. That statutory phrase in connection with the conversion needs to be interpreted in its statutory context. Of course it does, there's no dispute about that. That's an essential part of what purpose of interpretation is. Two, in the context of BPRA specifically, we know, and now from Mr. Gammy has touched on some of these points already, that Parliament chose to grant allowances not just for expenditure on the conversion of the building, but also for expenditure in connection with the conversion. And part of the significance of that one can see, by way of example, in the judgment of the House of Lords in Benedico. Took you to that earlier. We saw, for example, the observation of Lord Wilberforce, it's in Authorities 131, page 461 of the report, that when he was dealing with finance costs, that concept of expenditure in connection with the construction of the oil rig, he saw that as apt to include the finance costs, but of course the conclusion of the majority was that the concept of on the provision of that was not sufficiently wide to catch those finance costs.
Well, master of language as Lord Wilberforce was, that's a fairly slender indication, isn't it?
And one needs to look, of course, much further, and that's exactly what I'll be doing. But the only point I make at this stage is that we know, and this isn't just Lord Wilberforce, this is by reference to the general approach of Parliament in the capital allowances context, that we see frequently repeated on the provision of, on the construction of words of that nature. The words in connection with are much less usual, and they are, in my submission, intended, when we look at the detail, to have a broadening effect beyond.
Well, I think that's common ground. The question is how broad.
Correct. Third point, and this does go to the breadth of the concept, it is important to bear in mind, in my submission, that the result of the conversion that we're interested in, it needs to be qualifying business premises. You ought to have seen that from the key definition in section 360B sub 1, and that definition of qualifying business premises is in section 360D sub 1. It's in Authorities, page 12. We don't need to turn it up. You will recall it's premises used or suitable for letting for use for the purposes of a trade. So what Parliament is interested in is the end product. And what the taxpayer has to do, if allowances are to be available, is to turn a previously disused building into something that is useful, that is used or suitable for letting for use either in a trade or as an office. And I do say, against that background, that the Upper Tribunal was absolutely right in its observation in paragraph 151 to emphasise that Parliament was interested in the outcome of the conversion process. There has to be some end product. We're not interested in works being done for their own sake, but we're not just interested in works being done for their own sake.
But the end product doesn't need to have a business running, does it?
No, it doesn't.
Because as long as it's suitable and available.
It has to be suitable and available. Yeah. And yes. And no, it reminds me that it has to remain. It has to remain in that state.
Yes.
Suitable and available for 7 years.
Yes, indeed.
Otherwise, the relief is withdrawn. Yeah. But your logic was right to say it doesn't have to pick up, if I may, a couple of criticisms of that paragraph in the Upper Tribunal's decision that were made this morning, which I say, with respect to my friend Mr. Macklin, were misplaced, because there was a suggestion that the Upper Tribunal had gone too far in the reliance that it placed on that concept of qualifying business premises. What it did in 151 and then 154 and 155, and as we'll see when we get into the detail, that was then relied on as a second element of that feedback loop, and we went back to those paragraphs for some of the other items. There's not to deal with that now. And your Lordship will recall, if you go to paragraph 151 in the Upper Tribunal's decision, rather than be 202 or 203, in Core London, quite sure which page number the court has, but I have two different sets, but it's paragraph 151. The revenue placed some reliance on the reference to the building being open for business. And your Lordship will recall it was said, there you are, it's clear, it doesn't have to be open for business. They've forgotten what the definition actually is.
But the last sentence is wrong, isn't it, at 151?
No, it's not, because you have to read 151 as a whole. And you have to take account of what they're saying is put another way. They get it absolutely right in the second sentence. That correctly tracks the statutory text. What comes later is shorthand. They're not saying something different. They know they're not saying something different. Putting the same point in slightly different language is not in my respectful submission. And it certainly isn't some sort of doorway or a lever to crowbar open the Upper Tribunal's decision to say that can be upset. That would be a serious misreading of what the Upper Tribunal is actually saying.
Yeah.
Which becomes clear in my respectful submission when one then reads, and of course I'm looking at these paragraphs one by one, but the court knows and doesn't need me to remind it that the decision has to be read as a whole. But when one looks at 153, 154 and 155, of course the language alters ever so slightly in these paragraphs, but you can see the Upper Tribunal has it well in mind. First of all, in 153, got to look at the context. It's interested in, is it being used? But it hasn't just forgotten what it said in 151 a moment or two ago. In 154, it again reiterates the need for there to be use, but it's not just use. It has in brackets in line 3 and availability and suitability for use of the building. The Upper Tribunal's got this well in mind. And that point's repeated in 155. So I do say that those criticisms, which were a very important part of the submissions this morning, they take an unduly narrow and nitpicking approach to this decision. The Upper Tribunal was well aware of what the definition of qualifying business premises was, and correctly recognised that in these paragraphs in its decision. It then applied that reasoning and that logic when it looked at the specific items. It was also absolutely right in 155 to take into account the actual use that's intended. And of course here we're dealing with use as a hotel. And this is simply quite a prosaic point. That which counts as expenditure on or in connection with conversion is likely to be affected by what it is that the taxpayer is trying to convert the building into. One might need different things to be done for a regular office block, a laboratory, a hotel. And we will see, particularly when we look at what I call franchise costs and the importance of the brand, that the fact that what we're dealing with is a hotel business, that is a matter of significance when we're looking at whether there is a sufficiently close connection in order for the expenditure to qualify. So that's the third point. And the fourth and final framing point is this. In this particular statutory regime, where Parliament has chosen to exclude particular types of costs from the allowances regime, it has done so expressly. And therefore Mr. Gammy's touched on, for example, the land exemption. This is an exception in section 360 FLP sub 3. We touched on the exception for extensions. There's one for plant and machinery as well. I simply note that as this court observed in Barclays Bank case, paragraph 30, that where that's been done, paragraph 30 of Barclays Bank Authorities, page 362, I think we did look at this yesterday. It's Lady Justice Arden's observation that when that has been done, it's those limitations that should be being applied, and one should not be looking somehow to read down the central concept of in connection with. That, of course, doesn't remove the need to determine what does it actually cover.
Yeah.
But it certainly reminds one to guard against an unduly narrow approach to that provision in this particular context. So what are we looking at? We're looking at costs relating to the exercise of turning flush house from a disused float training centre into qualifying business premises. Bearing in mind that those qualifying business premises here were a Ramada Encore hotel. That requires, and this is exactly what the Tribunal and the Upper Tribunal did, a factual inquiry into the relationship between the expenditure and the conversion. And we have to bear in mind that it's not just about what works have been done, it's also about bearing in mind the result of the work. So a building that's used that is suitable for letting for use for the purposes of trade. And that's the context for the analysis of each of the items that I'm going to deal with. In relation to the IFA and promotion fees, if I can start with what I say is the correct analysis, just set that out relatively briefly, and then turn to the revenues primary and alternative case. I'll see how far I get. I don't think I'll get to the end.
No, that's all right.
But I'm very happy to get as far as I can. I think the court's in to rise at about 420. Is that?
We normally rise at 4:15.
Oh, I'm so sorry. Well, so, correct analysis on the IFN promotion. Starting point, the investor's equity, that produced money. And the money was used, among other monies, borrowed money from the co-op bank, to finance the conversion of property. And we know, this is obvious from the kind of legislation that we're dealing with, that what Parliament is trying to do by having these unusually generous capital allowances, 100% first year allowances, it is looking to encourage expenditure that meets the statutory conditions. And we know, just as a matter of practice, this is the burden of the reference to Mr. Douglas Smith's evidence in our skeleton on this. His paragraphs 4.28 to 4.29, which are in the supplementary model at page 867, they don't say very much, but they just say that encouragement is something very long-standing. It started off with the old enterprise zones, and he makes the point the same logic had been carried through into the BPRA world after the end of enterprise zones. So there's that statutory encouragement for people to incur expenditure on projects that answer to the statutory description. Second point, what are we actually dealing with? Well, the IFA fees, they were payable by Downing Corporate Finance Limited. It was the promoter for the purposes of the financial services regime. And it was agreed that OVL reimburse Downing Corporate Finance Limited for those fees out of its developers' profit. That's what we see in paragraph 206 of the first tier's decision. And we know, and there was evidence about this from Mr. Lewis and Mr. Tracy, that had been the practice in the enterprise zone context for other Downing arrangements. It had also, as it happens, and we got this from Mr. Smith, this paragraph 4.74, it had been the norm in enterprise zones any project, and particularly quite a large-scale project like this, it could be financed in a number of different ways. Equity finance is one, debt finance is another. We do make the observation, and we maintain, that of course, in this case, there's been some discussion of the bank arrangement fee. It has never been disputed that the bank arrangement fee is expenditure incurred at least in connection with the conversion. So the scale is inconceivable that a bank arrangement fee wouldn't qualify. My Lord Justice Lewison touched on this morning on the question, what is the logic of your case actually, that perhaps you were too generous? I think was the sort of how the question might be taken. I say that if one's looking at the statutory context, we're looking at a situation where the taxpayer has gone out to get the money to do the conversion. That is perfectly apt to fall within the concept of expenditure incurred in connection with that conversion. And there's no principal distinction in my submission between the bank arrangement fee and the cost of raising the equity finance. And when I say the IFA fees, that's how they should be seen. Now from Mr. Macklem, and I'll probably get into a bit more detail on this tomorrow, he described a number of times, well, it's a marketing fee. And it may be what he meant is, well, it's somehow akin to a marketing fee. It's not a marketing fee. There were fees paid to independent financial advisors. The reason that they got those fees was they were charging commissions for putting the product in front of their clients.
I mean, it might be said that the IFA fees are, so to speak, at one remove. So you want to borrow money from the bank, and the bank is going to charge you an interest rate and an arrangement fee. And let's assume that that's all right, that falls within the scope of the BPRA. But you engage a broker to advise you, the borrower, on the various products that are available on the market. Is that part of the cost of borrowing? Because that's closer to the IFAs who are as I understand it, advising the individuals whether this scheme is a good scheme to invest in, as opposed to a variety of different ways of sheltering tax.
So the example your Lordship's just put to me is I think one further away from the IFAs perhaps than themselves, in the sense that I think it's the taxpayer himself getting advice about different forms of funding.
Well, that seems to be what happened here.
My answer is that it wouldn't be right to regard that as being relevantly different from the bank arrangement fee.
Yeah.
Really for the simple reason that this is ultimately a cost of raising money. That's what a bank arrangement fee is. It's the fee that the bank is charging as consideration for making the loan.
Yeah.
Of course, it makes its own interest rate and all the rest. There's no good reason in my submission for distinguishing between debt finance and equity finance in this context. There were three specific reasons were relied upon for why you might draw that distinction. They were raised already for the first time this morning. I'll deal with those, I suspect, now, first thing tomorrow morning. But I'm going to deal with those points that were being made.
Or would that be a convenient moment to stop then, Mr. Brenner?
It would. That takes me to almost at the end of the correct analysis, and then I'll turn to the
Right. Thank you very much. So 10:30 tomorrow.
All right.